who are elected members of the National Assembly, the Deputy President under the 2010 Constitution is elected together with the President and holds no other public office. The above changes were not without reason. In the book, The Constitution of Kenya, commentary by Louis and PLO Lumumba, this is the second edition, Strathmore University Press, there 2019 at page 453. The two eminent authors had this to say, and I quote: "With the other arms of government considerably weakened, the executive personified in the president exercised unchecked powers. Indeed, during the constitutional review process, the CKRC noted that the powers granted by the Constitution and the ordinary laws to the elected president seemed to share characteristics with those of the colonial governor. It then resolved during the constitutional making process to divest some powers from the president with the aim of avoiding an imperial president." End of quote. The above cannot be far from the truth. In the pre-2010 constitutional era, the president held immense powers, including the ability to appoint and dismiss the vice president at will, and the discretion to assign or to withhold duties for the vice president. Consequently, the vice president served entirely at the president's mercy. That was the framework that the 2010 Constitution sought to transform. Under the 2010 Constitution, the office of the Deputy President has been fundamentally redefined. It is now safeguarded from arbitrary and capricious actions by the President. Article 172 grants the Deputy President specific constitutional functions in addition to any duties the President may assign. This provision was intended to address the previous situation in which a President could, for any reason, choose not to assign any duties to the Deputy President, effectively sidelining them. Thanks to the 2010 Constitution, even if the President does not assign any additional duties, the Deputy President still has specific constitutionally mandated functions to perform. In this way, the Deputy President is no longer at the mercy and the discretion of the President. Under the current constitutional framework, when the office of the Deputy President becomes vacant, two outcomes flow. First, any functions that were assigned to the Deputy President by the President automatically revert to the President. Second, the functions expressly conferred upon the Deputy President by the Constitution do not revert to the President and cannot be performed by anyone else. This is a departure from the 1963 Constitution, under which the President could appoint a minister to act as Vice President in the Vice President's absence. The 2010 Constitution includes no such provision. Therefore, if the office of the Deputy President is vacant, the specific constitutional functions assigned to that office remain unfulfilled. For clarity, not even the Speaker of the National Assembly may discharge the functions vested in the Deputy President under Articles 147, Sub-Article 2 of the Constitution. In light of the above, we are convinced and hereby find that the current constitutional framework does not envision any scenario in which the office of the Deputy President will remain vacant, except during the brief period required to fill such a vacancy. Another equally important provision that adds credence to the above position, that the office of the Deputy President cannot be left vacant, is Article 146(3) of the 2010 Constitution. However, before we interrogate the said provision, suffice to note that Article 150, Sub-Article 2 of the Constitution, which is on the removal of the Deputy President, has it that the provisions of Articles 144 and 145 relating to the removal of the President shall apply with the necessary modifications to the removal of the Deputy President. Returning back to Article 146, which article deals with the vacancy in the office of the President, Sub-articles 1, 2, and 3 of that article provide that follows. These ones I'll read. Sub-article 1, the office of President, read Deputy President, shall become vacant if the holder of the office A, dies, B, resigns, in writing addressed to the Speaker of the National Assembly, or otherwise ceases to hold office under Article 144, which deals with removal of President on grounds of incapacity, or Article 145, which deals with removal of President by impeachment, or under any other provision of the Constitution. Sub-article 2, when a vacancy occurs in the office of President or Deputy, 1, the Deputy President shall assume office as a President for the remainder of the term. 2, if the office of the Deputy President is vacant or the Deputy President is unable to assume the office of President, the Speaker of the National Assembly shall act as President, and an election to the office of President shall be held within 60 days after the vacancy arose in the office of President. Sub-article 3, a person who assumes the office of President under Clause 2A or following an election required by Clause 2B shall, unless otherwise removed from office under this Constitution, hold office until a newly elected President is sworn in following the next regularly scheduled election under Article 136, Sub-article 2A. End of Sub-article 3. Therefore, to us, a holistic reading of Article 146 alongside Article 152 of the 2010 Constitution, and in relation to the filling of a vacancy in the office of the Deputy President in this matter, yields the meaning that the person who assumes the office after the impeachment of the Deputy President shall, unless otherwise lawfully removed from this office, hold that office until further orders of this court or until the current term of the President ends, whichever comes first. The foregoing demonstrates that the structure of the Constitution, which reflects the popular will of Kenyan citizens, envisions a scenario in which the office of the Deputy President will always be filled except during the brief period of required to fill the vacancy as already stated above. Based on the foregoing, we now turn to the nature of the conservatory orders in this matter. It is widely accepted that the purpose of conservatory orders is to preserve the status quo pending further orders of this court. The Supreme Court in Gatirao Peter Munywa and Dixon Mwenda Githinji and 2 others said as much. In this case, maintaining the status quo would mean, 1, that the first petitioner remains impeached under Article 145, sub-article 7, which affirms the finality of the impeachment process with the following provision, I quote, if at least 2/3 of all members of Senate vote to uphold an impeachment charge, the Deputy President shall cease to hold office. End of quote. 2, additionally, the prevailing status quo will mean that the Deputy President nominee, Professor Abraham Kiture Kindiki, does not assume office. With such an approach, while such an approach may seem fair, reasonable, and balanced, and one which this court would ordinarily be inclined to adopt, the unique nature of the Deputy President role under the 2010 Constitution suggests a different course. Allowing these orders to stand will leave the office of the Deputy President vacant. The problem, however, is that no other person is authorized to carry out the constitutional functions specifically assigned to the Deputy President under Article 147, sub-article 2, once those assigned by the President revert to the President in the absence of an office holder. The result would be a de facto suspension of Article 147(2) of the Constitution, an outcome that no court should knowingly permit. For clarity, this court firmly holds that no court should issue orders that have the effect of suspending the operation of any provision of the Constitution, such an outcome is clearly not envisioned by the document itself. The Constitution was not handed to Kenyans on a silver platter. No, it was achieved through great struggle and sacrifice. Therefore, it is the duty of the court to uphold its provisions as intended by the framers and as demanded by the people of Kenya. Furthermore, Article 259 of the Constitution mandates that the document must be interpreted as always speaking. This means the Constitution is a living document designed to address contemporary challenges and to be applied consistently and continuously without interruption. Suspending any provision of the Constitution, even temporarily, would undermine this principle by creating gaps in its operation and disrupting the intended balance of governance. The Constitution is structured to ensure that all its provisions are effective and operative at all times. If any provision, such as Article 147, Sub-Article 2, is rendered dormant by a judicial order, it risks setting a precedent where parts of the Constitution could be selectively switched off, effectively weakening the Constitution's authority and the protections it affords. Additionally, we are mindful that courts are guided by the principle of constitutional supremacy, which requires that all judicial decisions align with the Constitution's objective and upholds its integrity. Issuing an order that suspends a constitutional provision would directly contravene this principle, effectively placing judicial discretion above the supreme law of the land. This will be inconsistent with the spirit of judicial restraint and the court's role as a protector and not a modifier of the Constitution. For these reasons, we take the position that the Constitution must remain fully operational at all times, and no court order should have the effect of rendering any part of it inoperative or dormant. The court's responsibility is to interpret and apply the Constitution as a cohesive functional document that serves the people's enduring will and protects the structure of governance as established. Drawing from the above, we hereby find and hold that public interest in this matter favors giving way to the Constitution, which in any event is the will of the people. That is also the dictate under Article 3 of the Constitution, where every person has an obligation to respect, uphold, and defend the Constitution. We choose to abide by that calling. As such, public interest demands that the office of the Deputy President should not remain vacant. Whether the consolidated petitions will be rendered inhibitory in the absence of any orders. As we stated in ruling number 1, because the consolidated petitions challenge the entire impeachment process, the fundamental issues at stake remain live, even though the parliamentary proceedings have been completed. Furthermore, as previously noted, should any of these petitions succeed, this court will have no shortage of effective remedies to address the situation. The next issue is whether the applicants will be prejudiced if the orders are not granted. Regarding whether the applicants will suffer any harm if the conservatory orders are not granted, we find that no individual can suffer loss or damage when the Constitution is permitted to operate as intended. Allowing the constitutional process to unfold does not in itself result in detriment, as it upholds the rule of law and respects the framework agreed upon the people. The applicants also urge the court to grant the conservatory orders, expressing concern that the respondents have a history of disobeying court orders, and that once the office of the Deputy President is filled, it will be impossible to remove the appointee, even if the petitions were successful. However, this court takes the view that it cannot operate under the assumption that its orders will be disregarded. This country has legal mechanisms to address any acts of disobedience of court orders. Moreover, the Honorable Attorney General, through Senior Learned Counsel Professor Gitu Mugai, has given an undertaking to comply fully with any orders which would be issued by this court in this matter. As such, we find that the applicants do not stand to suffer any prejudice in the event the conservatory orders are not granted.
This position, as we conclude, we reiterate that this matter holds significant public interest, and we remain committed to an expeditious examination of the petitions. Therefore, we will further provide directions within this ruling. Consequently, the following orders are hereby issued. 1. The applications for conservatory orders are hereby disallowed. 2. The conservatory orders issued on 18th of October 2024 in Keregoya High Court E015/2024 are hereby discharged and or set aside. Costs of these applications shall be incurred. We grant leave for appeal, type proceedings, and certified copies of this ruling to be availed to parties at cost or as it may be. We will mention this matter on 7th of November 2024 at 2 p.m. in the open court. This ruling shall forthwith be uploaded